What is going on, One Life family? So today, we're talking about, the thug trial just ended, and so Fani Willis, she had a court date today, and I'm going to play for y'all what happened at her court date because they're trying to get Fani Willis to produce certain documents, trying to say where she spent that money at and stuff. And Fani Willis is saying that hey, she's an elected official, and they don't really have to answer to people and things of that nature with their funding. Let's check out and see what happened at the Fani Willis trial.
Statute. The General Assembly knows how to grant subpoena power to committees, as it's done so in the past, and the General Assembly and the framers of the Georgia Constitution know how to distinguish between the General Assembly as a whole and an individual chamber such as the House and the Senate. Now, there's a reason in the Constitution and in the statute, and I guess I'm the oldest one that has been through all this. This has been debated many, many years. And there's a reason that there is not just one house can run off and start investigating. They can investigate whatever they want, but they have to have.
Do y'all think that Fani Willis should have to answer to the committee? Y'all let me know in the
The
comments.
statutory power
Should an
to
elected
issue a
official, a
subpoena.
person that is
There's a
elected,
reason. What if the Senate decided they were going to form a committee to investigate the House? Call the Speaker. Let's subpoena him up. Why are you not calling Senate bills up? That is ridiculous. And it's the reason that the power has been kept from individual houses and has to be devised by statute. Now, the committee, in its brief, cites Coggin versus Davey. Frank Coggin was a member of the state Senate. He was from East Point. And in 1974 and 75, this was a big issue. The conference committees met in secret and what they called executive session. Conference committee is when the House passes one version of a bill and the Senate passes another version. The president of the Senate and the Speaker of the House appoint three members, and they get together and they come up with agreed to language, and then that's adopted. Well, the conference committee, particularly the one on the budget, was done behind closed doors. And so the press, rightfully so in my view, said, that's not right. You're spending billions of dollars. Well, the budget back in 75 was less than
exactly.
$1 billion. It didn't cross $1 billion until the late 70s and $2 billion in the early 80s. Now it's 32 or 33. But the press sued Frank Coggin and the members of the General.
I'm glad that you said that because I want
to. Says we should be allowed in.
I'm not gonna keep stopping it, but see, I'm glad you said that because this trial and this hearing that they having to get these documents, it's gonna show. See, I wouldn't be surprised if Fani Willis spent a good amount of money trying to lock these dudes up. Mind you, she just blew the case. They walked away with probation and two of them found not guilty. You just blew millions of taxpayer dollars. You feel me? You just blew a lot of money. So they want to see how much did you spend on this trial? How much did you spend on yourself? How much did you actually spend on the jail and the cases that got people sitting in that jail? But I just wanted to say that. But let's check it out, y'all. I appreciate y'all for pulling up, man, and checking it out with me.
Under the Georgia Sunshine Act, they said no. Supreme Court said no. Said, listen, the General Assembly is not defined as an agency, and that is subject to the Open Records Act. So they are not subject to the Open Records Act. And Judge Gunner, in the opinion, says if the General Assembly wants more sunshine in, they have the power to do it. They only have to change. Now, this has been cited for something that is completely different. That's all this means, is that Coggin versus David simply means that the General Assembly is not subject to the Open Records Act. The second issue, so the first issue we have here that we claim is dispositive is what the statute says. Title 45 says only the General Assembly has the power of subpoena, not the Senate, not the House. The governor has that power, of course, but a bill must be passed or a joint resolution. Now, there's a difference, and I noticed this in rereading the briefs last night. And so when we passed a resolution can have the force and effect of law, but it has to be passed through both houses, and it has to be signed by the governor. It cannot just, and it's loosely used by my distinguished friends here on the other side, it's loosely used as well. There's language that says resolutions. Resolutions that have the force and effect of law have to pass both houses and be signed by the governor. So we come back to this basic premise. It says that just what it means, what it says, and says what it means. In addition to the power conferred upon the Attorney General in this article, the governor or the General Assembly is authorized to make investigations and the authority to issue subpoenas and for production of documents, not just the Senate. Now, they're going to argue here, as they have in the papers, and I know you've read all this, oh, well, that doesn't mean we can't rule ourselves. You can rule yourself. You can pass a resolution or a rule that says that every member of the Senate is subject to something, but you cannot go outside and issue a subpoena unless the General Assembly approves it. And it is done by joint resolution or by statute. Now, the second issue that I'll posit to you today is this. This committee, and I'm going to talk more about how all of this occurred.
Wouldn't it be crazy if you could create voiceovers that sound like a
raspy old man,
a young teenage girl,
or
This committee issued this subpoena after Adjournment sine die. You've seen sine die on the television where they throw all the paper up in the air. You know, I never have understood why they do that. But sine die simply means not to meet again. That's exactly what it has. And so what happens is Georgia is a General Assembly. It's a 2-year session. And on the second year, which is an even numbered year, when it adjourns sine die, it is gone. It has no more force and effect. So what we suggest to you is there's not a direct Georgia case on this, but there's plenty from Congress that says that after the General Assembly adjourns sine die, that is not to meet again, that it has no power to do anything. It cannot issue a subpoena. Can it meet? Yes. Can it make recommendations to the next General Assembly? Sure. But it does not have the compulsive power of the state to summon someone before them under the pain of contempt. There's one of the early cases in 1821, they tried to hold this fellow in contempt to Congress. But the Congress, which I think one of the things wrong with the federal government is they stay in session all the time, but they used to adjourn sine die, not to meet again. And in Anderson versus Dunn, against Dunn, it was an 1821 decision of the Supreme Court of the United States. It held that the contempt power died with the Congress. That is, you couldn't hold somebody in contempt after the Congress had adjourned sine die. Peterson versus Elko, which is a Nebraska Supreme Court case in 2019, committee investigations and attendant subpoenas are presumed to cease to exist at the end of the term in which they are commenced. Two separate Department of Justice memorandums from the Office of Legal Counsel under both the Reagan and the Clinton administration held likewise that when the Congress adjourns, that's it. They can't issue a subpoena, they can't punish for contempt. Now, the way they get around that up there now is they don't ever adjourn. But Georgia has a limitation on the number of days you can meet. So so that would be more difficult in Georgia. The resolution, House Resolution 978, says that the General Assembly adjourned sine die on March the 28th, and they did so. They ceased to exist. Now, from the opinions of the Department of Justice, it says, I'm just going to quote from part of it, this understanding that Congress subpoena power inheres in and is ancillary to the power to legislate leads logically to the conclusion that the legal obligation to comply with a congressional subpoena lapses upon the cessation of Congress's authority to legislate. So they can't have it both ways. They say, well, we can, yes, we adjourn sine die, but we can continue to issue subpoenas and punish for contempt. They can't have it both ways. Either they're in session or they're not. The decisions of the federal courts dealing with the Congress make it very clear when the Congress ends, its power ends. Now they're going to argue with you, well, we form all these study committees. They form all these study committees so they can get the per diem every day, to come to Atlanta and get paid a little bit and all of that other stuff. I've never seen one that did much, but they do it. And I'm not saying that's their business, that's their constituents. But you cannot, under pain of contempt, bring about and punish somebody for not complying with the subpoena because they had no power to issue a subpoena after the General Assembly adjourned. Now, the next point, so the statute means what it says and says what it means. That's number one. We think that's dispositive of the whole matter.
It says what it
Number
says,
two,
it means what it means.
General Assembly adjourned sine die. That's it. They can study all they want to, but they can't hold somebody in contempt or subpoena them after they die, after the sine die. The third point is the subpoenas are overbroad, even if you got past those first two.
Supercharge your business with the all-new Shopify point of sale, the all-in-one POS.
We set forth.
They trying to see what she did with that money.
What is asked or produced? All documents relating to
Well,
the
the county
personal
was lit today, wasn't it?
relationship between you and Nathan Wade from 2019 to the present day. I told somebody now, if the General Assembly is going to start investigating sex, they ain't going to be able to have a quorum before the General Assembly to act on anything. But in any regards, then it says all documents relating to services performed, all documents referencing or containing text messages, all documents. I won't go on, but listen, there are privileges here that apply. There's a work product privilege. There's a prosecutorial immunity. I mean, this obviously what they were trying to do. Here's the president-elect, got elected. He's my president. He's everybody's president. But what they were trying to do was chill the prosecution of Donald Trump and find out what they had. That was all this is about, and as I'll discuss just a little bit later. The subpoena ducis tecum seeks every email or text sent by the former special counsel to the district attorney, including privileged emails concerning state versus Trump. All written work product generated by the former special counsel in the course of working on State versus Trump. All documents sent to or received from the Department of Justice. Now, can you believe that? It says, we want to see what you got from the Department of Justice, regardless of any privilege. That's what they say, regardless of any privilege. We suggest to you that the law is clear, even under a civil case, that the subpoena is overbroad, even if it was validly issued, even if they could issue a subpoena after they adjourn, sign, they die. Then they talk about Gonzalez versus Miller and says, well, this is just the end all to our questions. Let me tell you what happened. Deborah Gonzalez was district attorney of Clark County. She is till January. She got beat by an independent candidate down there, whose name I cannot pronounce. But anyway, there's a lawyer who got somebody to make an open records request on the district attorney. The committee claims, and she says, listen, I'm a part of the judicial branch. That's where she's placed in Title VI of the Constitution. And so therefore, the judicial branch is not subject to the Open Records Act. And so therefore, I'm not subject to the Open Records Act. The committee claims that Gonzalez against Miller justifies the breadth of the request. And this lawyer asked for everything. And what the question before the Supreme Court was not on the breadth. And anyway, it's an open records request. It's not a subpoena. What Gonzalez has recognized, however, is that work product, attorney-client privilege objections to open records requests were not subject to the Open Records Act. It said that she was, the Office of District Attorney was, because she did not decide cases and therefore was not a part of the judicial branch. She had to interpret the law, that her job was to prosecute the cases, and that she therefore had an executive function that overrode the placement of her in the Sixth and Title VI. And at the Constitutional Convention, that was a big debate on where the district attorney should be. I won't get into whether they were right or wrong. But the main thing here is that it shows you how overbroad their requests are, and the case particularly holds that the attorney-client privilege, the work product privilege, the prosecutorial, all of that, those privileges apply even to an open records request. Those are gathered, that's on page 18 of the opinion, and it's in note 15. It gathered all the cases applying work product and pending prosecution objections to the Open Records Act. And further, the Open Records Act has statutory protections for work product. None of this, I mean, this rump committee created by one body of the General Assembly says, oh, wouldn't it be fun for us to just drag the district attorney down here and see what she's got on old Donald Trump? Let's just see what she has. None of these protections are in what has been done in the resolution or in the subpoena. Thus, we suggest to you that the petitioner and their subpoena that says, well, you can't claim privilege, and I always says who? Privileges are matter of statutory and common law right. The one house of the General Assembly does not have the right to override what the common law is. My goodness, imagine what they'd do if one house could do that. All right. Our next point is that this violates the separation of powers.
Spark your next big video idea with Motion Array's AI voiceover.
Now, this comes back to a case dealing with Donald Trump that went to the Supreme Court of the United States. It's called Mazars versus Trump. The House decided they'd investigate Trump. How much taxes have you paid? How much have you done this? What kind of deals have you made? He objected, rightfully, I will tell you. I think the House committee overstepped too. So here's what Mazars against Trump said. This is a 2020 case. It says, we're not going to say that they can't do some, that is the House committee, because they have the right by statute to subpoena. But they said this, because the subpoena power is unenumerated in the Constitution and justifiable only as an adjunct to the power to legislate, it is subject to several limitations. Legislative subpoenas to executive branch offices involve two different political breaches of government and thus implicate weighty questions regarding the separation of power. The Supreme Court went ahead to say the legislative branch may seek to exert an imperious control over the executive branch and harass it. And so therefore, we're not saying you can't do it. And all their cases says, well, this doesn't apply. Says there's cases that say you can legislate. Yeah, of course you can legislate. You pass both houses of the legislature. But you cannot harass a different branch. Given these concerns, the Supreme Court set down several limitations. So number one, the subpoena must serve a legitimate legislative purpose. Number two, it may not be issued for law enforcement purposes, because that's the executive branch's domain to enforce the law. And the recipients retain common law and constitutional privileges. Now, so therefore, let's look. Is there a legitimate legislative purpose? The Mazars Court further specified that the courts that examine these kinds of subpoenas.
I am a better marketer with SEMrush AI. I can make informed marketing decisions. I can forecast my traffic.
Should look at several factors to decide whether there is a legitimate legislative purpose here. They said, does the asserted legislative purpose warrant the significant step of subpoenaing an executive branch official? To narrow the scope of possible conflict between the branches, courts must insist on a subpoena no broader than reasonably necessary to support the legislative objective. The legislature must offer detailed and substantive evidence of its purposes, not vague or loosely worded, like, oh, we got oversight over the district attorney's funding, and so therefore we can look into it. That's a vague, and it's just a pretext. And the burdens imposed by congressional subpoenas should be carefully scrutinized because of the potential for constitutional conflict between the branches. Then it went ahead and says other considerations may be also important. So Mazars in practice has held this, that in the McLaughlin against the Montana State Legislature.
What's up, Scott? What's up, chat? What's up, everybody?
Case in federal court. They said, listen, y'all issued a subpoena, but you're not exercising functions reserved to another branch.
Just so y'all can know what's going on, I'm playing the Fani Willis hearing, which is they're trying to decide if the committee has enough power to make her turn over her receipts and documents and everything like that, which is very interesting because you see how this trial just ended. They didn't really get nothing. Y'all utilized all these resources, jeopardizing lives to all these families. You got a jail that people losing their life and their families are jeopardized. You just corrupt on so many levels, right? And you're just dragging people in every kind of way around Fulton County. And now they like, look, we gave you money to fix the jail. We gave you money for backlogs. We gave you money for all kind of things that could have put Fulton County back on the map. But instead, you chose to go after YSL. You chose to take this money, go spend it on you, go spend it on this. I'm just saying what they're accusing her of, and I get it now. You know what I'm saying? And so you spent it up with Nathan Wade. You sound like you took him for his 50th birthday. You misappropriated funds is basically what they saying. And I believe she did it with the intentions of thinking that, okay, well, we done did this bust on Thug. We got this property. We finna get this conviction. We got all these witnesses. You know how sometimes you would just kind of jump the gun, so to speak. And now look, you spent all these taxpayer dollars. The jail is still messed up. They're not giving you no more money for that. Man, it's messed up, and they want to know, man, where that money at that we got that? Because if they pull it off, they gonna try to lock her up for that. I know it's a code violation, but depending on how deep it is, But then the other part is, like they're saying, because she's an elected official, when you go and vote, you vote Fani Willis and these people into office. So one of the things that Commissioner Rob Pitts had said before is that, well, look, don't get mad at the people that's in office. Get mad at the people that's either voting or not voting. So these people are in office. This is Rob Pitts. They said they've been more than generous with Fulton County, with the district attorney's office, and even giving them up to $75 million at one point in time. And they back down there saying that they need more money while the doors at the jail still ain't working. And the money that they gave you to get these old cases brought up, you still got people sitting there. Mind you, the YSL case is like, what, 3 years old. And you got people sitting there that's longer than that. But that's what's going on. And so I'm playing this information for y'all so y'all can see while Fani Willis is doing all this crooked stuff and got these young brothers on trial with no evidence fighting for their life. Now, imagine a person like Lil Rod, like I was saying earlier, who ain't got the funds or the knowledge or, you know what I'm saying, the support to go through what these brothers just went through. They'd have been crashed out and probably went to prison 15, 20. See how they did Lil Rod? Caught up in something they don't even know about, too young to understand, and end up in a place that they don't want to be and not understanding how they got there just in the blink of an eye. It happens. But the point is, while they down the hall doing that, you feel me? They up here telling Fani Willis, hey, you got to explain this what's going on to us. And again, y'all let me know, do y'all feel like she should have to answer to the committee, or is an elected official? What's going on, Kiki? Or in y'all opinion, is an elected official somebody who just control their own stuff?
They went ahead to say that and that's legislative. Let me tell you what that subpoena was. It was a subpoena to the judges to investigate judicial bias in the courts. And the federal court said, no, wait just a minute. You can't do that. You can't do that. You've got, it's just not a proper executive function or a proper legislative function. And it could not act as a law enforcement or trial agency. That's Watkins against the United States, 1957 United States Supreme Court. And you could not seek to expose for the sake of exposure. Mazars again. And there is no evidence of a legitimate purpose at all here. And so it fails to satisfy even one of the Mazars tests. And they say, well, how do you know that? Well, we'd have to be blind to not see what all others can see and understand. That the subpoenas do not represent, this is exactly from Mazars, do not represent the run-of-the-mill legislative effort, but rather a clash between rival branches of government over records of intense political interest for all involved, that is, his income tax returns. They were targeted at one individual.
Atera is the IT painkiller. Remote monitoring and management, remote access, help desk and ticketing, smart automations, patching, software deployment, scripting.
Targeted at interfering with one prosecution, which is what this has done, and is done at the behest of the president-elect. And it's pushed by Georgia elected officials who in the first place sought to undermine the 2020
I ain't gonna lie, they need to
election.
make her say what she did with that money.
I have
Man,
heard
we in
for the
Fulton
last
County, we
4
ain't got
years
well,
from
man,
my
we ain't got
Republican
no
friends,
food enough. I mean,
y'all
y'all know how it
stole
is.
that election in 2020.
You ain't hardly eating enough.
I think the 2024 election shows Democrats.
It ain't, man, listen, you ain't hardly eating enough, shout. My entire life is going to insulin life improving. Yeah, I can believe it. I can believe it. You know what? I'm telling you, I ain't gonna act like I'm slow. I know she did. She did a little bit here and there, but for the most part, she misappropriated on funds. She was taking on trips. She was enjoying the money. She went and bought the house. She was buying her daddy houses, Nathan houses, 50th birthday parties. Um, she was doing a plethora of things, man. And the sad part about it is, you know, this happened, and I'm telling y'all, because I was in there in 2021. I seen it. That's why it's so sad, because at the time you wouldn't know this is what was going on, but now that you hear what's going on, it's like, dang. But in 2021, they had people locked up in there, man, who was sitting for. Fani Willis passed a law that said you got 90 days, bro. They got 90 days to indict you, or they can give you a bond. But it's 90 days off the muscle. You feel me? She passed that law. Now, mind you, she passed that law on top of it being COVID. And Fulton County Courthouse and a lot of other ones, I don't know about in other states, but I know Fulton County Courthouse was shut down completely. Nobody was going to court, and that lasted for about a year. They had the court system shut down. So you had people that were sitting in Wright Street. That's when it started to get real off the chain. But you had people that were just sitting in Wright Street and couldn't go to court because the system was shut down. And mind you, they were already, like I had to say, me, he had been in there like 8 months already, like 8 months to a year or something. Then the COVID hit. So then that was shut down for another year. But the point is, they gave Fani Willis a budget to catch up with the backlog. But if you listen to them to this day, they're still behind, mind you. Again, that's what I was just saying. Thug case is a 2-year-old. They've been investigating him since 2015, but he's been locked up since 2022. It's a 2-year-old case. You going on 3 years. Well, you know, a little longer than 2 years, but not quite 3. But it's too long for Shannon Stillwell and Yak Gotti to have sat in there this long for something that y'all know y'all couldn't prove. I could see if they actually thought they had a chance to prove it, but this was a distraction from the funding. Okay, they didn't have the money. There go your problem right there. There go your problem right there. We just said it. The state didn't have the money to beat them boys. Let's get back to it.
Democrats are not organized enough to steal anything. And it was ridiculous from the very beginning to say, well, we want to look into Fani Willis because she's prosecuting Donald Trump, who on a telephone conversation told the Secretary of State, can't you just fix this for me? Can't you just find me so many votes? Just a few. That's all I want. So, and how do we know that? Well, we know this. The vice chairman, or I don't know if he's the vice chairman, Senator Dalzell, whispers into the ear of the chairman. He's the one that signed a letter to the governor, says, after the 2020 election, we need to call the General Assembly into session. Now, the Lieutenant Governor did this too. He was state senator at the time. So that we can override the vote of the people of Georgia, that we can select the electors ourselves. rather than what the people voted upon. We also know, and we have here, that he felt so strongly about it that he, Brandon Beach, Burt Jones, who's lieutenant governor, the state senator, signed an amicus brief for the Supreme Court in the Pennsylvania case saying they stole the election from us in Pennsylvania. This is not a legitimate legislative purpose. This is nothing but a charade. As Mazar said, we would have to be blind to see what all others see. One district attorney, did I hear? I went to one of the hearings. And when I asked her, I don't generally go to the Capitol except when we're burying dead governors, but this was of such interest, I went up there. I asked the trooper at the door, I says, I hear that they are investigating district attorneys. He said, yes, it's up on the 4th floor. Same room, I might point out, the fake electors met in 2020. I said, well, I am sure they're going to have that lady, Jackie, whatever her name is, down on the coast, who failed to prosecute her former employee who killed a young African-American man just for jogging through the neighborhood. I'm sure she'll be up there and being questioned. I'm sure of all of these cases that have been found where there have been convictions of those who were innocent. I am sure that they're going to bring these district attorneys up and question them and see what went wrong. And when I get up there, all they're talking about is sex. Well, Fani Willis had an affair with Nathan Wade. This is a pretext. We would be blind not to see what all of us see.
We had to be
This was
blind.
nothing but singling out one person who's been duly elected in this circuit and duly reelected in this circuit to embarrass. It's not for any legitimate legislative purpose, so they would have been subpoenaing all these other district attorneys that have done these things wrong. Only one person. And that is an improper purpose. Now, I'm going to reserve my balance for rebuttal, but I want to say one last thing. You need go no further than to say, listen, the General Assembly knows how to grant powers to committees. And they haven't done it. They haven't done it. The statute says they can grant the power, but it has to be granted by the General Assembly and not by just one committee, not just by one house, not for just one purpose, to single somebody out to embarrass them. She's been embarrassed enough.
Thank you, sir.
How much time I got left, Judge?
10 minutes. 10 minutes.
10 minutes. Oh, that's good. I give another 4 minutes.
Afternoon, Judge.
Okay, now.
So I guess I need to share my screen. Is that the?
Yes.
Okay.
This should be interesting.
And you can come get your thumb drive.
Why do they why do they feel like this lady got to show them anything? She's an elected official. You know what? I feel like had she pulled this trial off, had she won this thorough trial and proved what she was out to do, she wouldn't owe nobody no explanation. But now you got some explaining to do.
Here we go. All right.
You want me to PowerPoint?
Yes, Your Honor. And if I may actually approach, I've got a notebook with a hard copy of it as well.
Oh, okay.
Judge is that Judge Ingle? Okay.
Good afternoon, Your Honor. I'm Josh Bellanfani, and along with my colleague Vincent Russo from the Robbins firm. here on behalf of the 9 members of the State Senate Special Committee, the special committee itself, which is intervened, as the court knows, and also Chairman Cowser of the committee, and Senate President Pro Tem, member of the committee, Senator John F. Kennedy, who are here with us in the courtroom today. As Your Honor knows,
John F. Kennedy.
It is in many ways a question of first impression, looking at the specific authority of the state Senate. Personality shouldn't matter. Politics shouldn't matter. It is a question of constitutional law. And as the Supreme Court said in the Gonzalez case, just as district attorneys play a critical role in, quote, enforcing the law by prosecuting criminal cases, the General Assembly also plays a critical role in making the law. And 2 specific provisions of the state constitution authorize the General Assembly to impose duties on district attorneys by general law. Another says that it can provide the means of sanctioning district attorneys. That's Article 6, Section 8, paragraphs 1D and paragraph 2. In other words, the General Assembly has an express authority to look at and therefore legislate over issues of district attorneys' offices and their practices. And in that vein, it passed Senate Resolution 465, which looks at those practices. And we know that because the operative paragraph 6A says, in the event the committee adopts any specific findings or recommendations that include suggestions for proposed legislation or changes in appropriations, the chairperson shall file a report of the same.
This game,
Oh no,
you're not ready for it.
The 6th whereas clause says the same thing, that they
know.
are looking
I
at
don't
issues
know.
in order to determine if legislation or changes to appropriations are necessary. Whereas inquiry into these allegations is a key word. Senate Resolution 465 does not say that the petitioner has done or not done anything. That's why they're investigating. They're investigating and making an inquiry into these allegations that may show that existing state laws, including those establishing the processes for selecting, hiring, and compensating special assistant district attorneys, are inadequate. That is the constitutional prerogative of the Senate as set forth expressly. Now, it's interesting that the petitioner and we actually agree on a lot. You're going to see there's a lot of the same quotes from cases, and the petitioner agrees on page 6 of its trial brief that the General Assembly has the authority to investigate. That's a given. So then the questions before the court are these. Does the state constitution prevent the state Senate or the special committee from issuing enforceable subpoenas? Answer, no. Is the special committee prohibited from convening and acting after the legislature adjourns sine die? Answer again, no. And has the petitioner properly objected to portions of the subpoena ducis tecum? Answer once again, no. And on that point, Mr. Russo will address it, but I'll just say at the outset, none of those arguments apply to the witness testimony subpoena in terms of overbreadth. So now what is the petitioner's burden? And I know the court has competing petition and a competing application before it. We weren't sure which side would go, so that's why we're sitting over here. And if it pleases the court, if we do have any remaining time, if we would be afforded just a slight rebuttal, and I would be fine to give opposing counsel a rebuttal to that as well. But what is the petitioner's burden? Well, in some ways, this court has already examined that. In the order denying the emergency motion, which is tab 1 in your notebook, no need to turn to it, it's just there. It says this court has the power to refuse to take some action to compel compliance should petitioner demonstrate that doing so would be inappropriate. But because of the nature and challenge of the petition, 3 other incredibly stout burdens of proof apply. The first is, and make no mistake, the petition is a facial challenge to Senate Resolution 465 and the authority of the state Senate, not just the committee, but the state Senate to issue subpoenas. How do we know that? Because it says in the petition, in the ad danum clause, they're seeking to declare the subpoenas are void because they fall outside the statutory grants of the legislative subpoena power, and the committee could not exercise legislative subpoena power. That's the authority provided in SR 465. So the court can't declare that without invalidating a portion of Senate Resolution 465. And we know in C, it says they asked to declare the subpoenas are void because they violate the separation of powers clause of the Georgia Constitution, not the federal Constitution, the Georgia Constitution of 1983. It is a facial challenge. And as the Supreme Court of Georgia said, and this is in your notebook at tab 2, because we don't cite it in our brief, but I think it's a well enough established proposition. A facial challenge is, of course, the most difficult one to mount, because the challenger must establish that no set of circumstances exist under which the act would be valid, meaning the state Senate could never issue subpoenas and enforce them. But there's also a presumption of constitutionality that the petitioner has to overcome, that Senate Resolution 465 is constitutional, that the subpoenas are constitutional, passed pursuant to it, and a presumption of good faith. And the presumption of good faith looks both forward and backwards. We cite in our brief the McDowell versus Judges Officio decision from 1975. This says the law presumes public officials will follow the law in the exercise of their statutory duties. Meaning, when the district attorney testifies, the presumption at this point is that the members of the committee, 9 members, bipartisan, will act in good faith. When the documents are submitted, they will act in good faith. But also it looks backwards. We also cite in our brief the Irvin versus Woodruff decision from the Court of Appeals in 1971. There the court speaks in the past tense. The court will presume in favor of public officers in the absence of all proof to the contrary that they discharge their duty in compliance with the law. In other words, the Senate acted in good faith in passing Senate Resolution 465 and in issuing the subpoenas.
Turn your ideas into videos. Go to artlist.io and get everything you need, all in one place. Music recorded by real artists. Stunning visuals produced to empower your stories. Sound effects created with attention to detail. Customizable templates that are easy to use. And AI voiceover with voices exclusive to Artlist. Go to artlist.io and start making videos today.
I bet you really wish you didn't have to watch this ad right now. Let me show you how to block it. Still here? Let me explain. It's a free Chrome extension that's actually made by one of the founders of Honey, and it basically blocks ads for you. Like, imagine watching YouTube and Twitch completely uninterrupted. And it actually gets cooler because if you do end up seeing ads, PyLegit pays you to see it. I didn't even know these were ads in the first place, but I made money off of them, which is great. It even has a visual mode that lets you watch your ads disappear. Like, why do I feel like I'm pulling a fast one on Google? It takes like 5 seconds to install. So honestly, just give it a try because who knows? This could be the last ad that you see.
So we look again at Senate Resolution 465. It's in your notebook at tab 3. I know the court has seen it, but it looks specifically at those issues identified. For example, lines 27 to 30. Inquiry into these allegations may show that existing state laws are inadequate to address various legal and fiscal issues raised. In the exercise of the Senate's authority on page 50 or lines 55 to 58, it is necessary to determine whether the alleged conduct of District Attorney Willis, if proven to be true in whole or in part, should be addressed by the enactment of new or amended laws, prompt some change in state appropriations, or both. That's why she's been invited to testify. They're not taking the position on whether the district attorney has done right, has done wrong. The Court of Appeals has that question. The state Senate is entitled to investigate whether there is a need to reform practices and it specifically identifies them. There's state money that flows to district attorneys' offices. That's the appropriation piece. And to the extent that there needs to be placed limitations on special assistant district attorneys, that's the legislative purpose. And the subpoenas are consistent with that. And there's two key points about the subpoenas. And this is why the issue is not just the authority of the committee. At the top, it says, by the authority of the Georgia Senate. It is a question of the Senate's power and not just the committee's power. And there's two. And again, the challenges on overbreadth are limited to the document or subpoena ducis tupis. So with that background, the first question before the court is, what is the state Senate's authority and the special committee's authority to issue subpoenas? Now, the petitioner says that can be determined by looking at statutes. We suggest that has it backwards. The question is not, is the state Senate authorized to issue the subpoenas? The question under the Georgia Constitution is there anything that prohibits the state Senate from issuing the subpoenas without the consent or some joint resolution of the House? Because I think the petitioner would agree if there was a bicameral decision that the House and Senate worked together on it, the subpoenas would be enforceable. So the question really before the court is, does the state constitution prohibit the state Senate from issuing the subpoenas alone? The answer is no. We look at the constitutional text that both sides cite. Article 3, Section 3, Paragraph 1, the legislative power of the state shall be vested in a General Assembly, which shall consist of a Senate and a House of Representatives. Both have some aspects of legislative authority. In order to enact laws that go into the code, it has to pass both chambers. That is part of the legislative authority. But we know that both have some, at a minimum, just by reading the text of the Constitution. And we know that too from Article 3, Section 4, Paragraph 4, which is in your notebook. We compiled a series of constitutional provisions that we'll refer to, but I just didn't want to clutter up the slides. There it says, interim committees may be created pursuant to the authority of the General Assembly or of either house. Pursuant to the authority of the General Assembly or of either house. Thus, there is authority within the houses acting alone. And we know from the Supreme Court of Georgia that the power of the General Assembly is, quote, awesome. The legislature is absolutely unrestricted in its power to legislate so long as it does not undertake to enact measures prohibited by the state or federal constitution. And where Senate Resolution 465 authorizes the issuance of subpoenas, that is the challenge and the attack that the petitioner makes in their petition. We also know, and we'll get to this on the Trump versus Mazars discussion, that the Senate has plenary power. Unlike the United States Congress, which has only delegated powers, the Georgia legislature is given full lawmaking powers. And that's why the question is, does the state constitution prohibit the state Senate from issuing subpoenas? Again, the answer is no. Part of the reason is we look at what the state constitution says about resolutions versus what it says about laws. And we know in this, several of these are put in your notebook at tab 6, that all resolutions are not intended to be the same as laws. Several provisions of the state constitution say no bill or resolution intended to have the effect of law, ... That's Article 3, Section 5, Paragraph 12. There's others cited in our brief today. Senate Resolution 465 is not one of those. And if the Constitution said, for example, no resolution seeking to investigate and issue subpoenas shall be passed by one chamber, great, then it can't happen. Or if you look to footnote 4 on page 7 of their trial brief, they cite provisions in the state constitution where both houses are expressly required, passing apportionment or reapportionment legislation or adjourning, that you need both chambers. And that's the second point, that there is no bicameral requirement or action of both chambers required in resolutions. Article 3, Section 5, Paragraph 14 says the General Assembly may provide for the joint sponsorship. Doesn't have to.
AI can be fun and games. SEMrush has made it all action. Make informed marketing decisions. Forecast your traffic. Generate impactful content. That's what SEMrush can do. And now you can too.
It's the Motion Array Epic Holiday Sale. Get 10% off the everything plan. Templates, music, footage, AI voiceovers, sound effects, plugins, and more. For a limited time only. Save with Motion Array and take your videos from good to the best.
The concurrent resolution one, the same one cited by the petitioner themselves, says that separate periods of adjournment may be fixed by one or more such concurrent resolutions, meaning passing both chambers. Article 3, Section 9, Paragraph 6, R5B also talks about a joint resolution and how it would be effective. The fact that it mentions joint resolutions and the fact that it says in here, here's where you need both chambers, it doesn't do that, the state constitution does not, with any investigative or subpoena power. In other words, Your Honor, they can't show you a provision of the state constitution to invalidate Senate Resolution 465 or the committee's action pursuant to it. That is the inquiry. Petitioner says something else. They say that it violates the Georgia separation of powers provision, but they rely on that on the Trump versus Mazars case, which is about the federal constitution. But let's look at the state constitutional provision. It says that the legislative, judicial, and executive powers shall forever remain separate and distinct. But as Justice Ellington wrote in the Gonzalez case, that provision asks about powers, not departments. The reason the petitioner can't prevail on their separation of powers argument is what they say on page 6 of their trial brief. The legislature has the authority to investigate. That's the power that it is exercising. And it is not, in doing so, violating the separation of powers. And we know that because of the Boston case and the analysis there, that because the General Assembly has the authority to pass legislation governing the offices of district attorneys, it can't violate the separation of powers provision by acting pursuant to that authority. So there's no provision of the state constitution that supports that, and that's what their petition claims. Again, it's a violation of the state constitution. But let's just look at the Trump case and see why it doesn't apply. Starting with Congress has no enumerated constitutional power, and because Congress must have an enumerated constitutional power to act, there's numerous restrictions placed on them. We know from the Bryan case that's not the same with the Georgia General Assembly. In fact, it's the opposite. But it's not just that. In the federal government, we have this idea of a unitary executive branch. And as the Supreme Court said in the Trump case, part of those limitations look at, quote, the unique position of the president. The president's unique constitutional position means that Congress may not look to him as a case study. This is a different case. This involves district attorneys in the executive branch joined by other state and local executive officers, and the Mazars case simply doesn't apply. So then they say, well, but Mazars says you need a valid legislative purpose. Your Honor, I looked at valid legislative purpose in the Georgia cases on Westlaw, and the only thing I could pull up was like equal protection analysis. Is there a rational basis behind this legislation? It's a federal standard that doesn't apply. In fact, it's created by federal case law. It's not applicable here in Georgia. That hasn't been applied. But also if we're looking at what is the valid legislative purpose, our own Supreme Court in Hollowell v. Jove says You look at the text of the resolution. And the text of the resolution, as we've shown, addresses issues that were covered broadly in the news that are now again.
All right, babe, I'm back, y'all. I'm back. I'm back.
And that the state Senate and the General Assembly have expressed constitutional authority to legislate about. It cannot be said that looking into those issues, and we've documented in our briefs how looking at DA's offices has gone back to the COVID year of 2020. And back then it was the Democratic Party and their leaders pushing it. 2021, same thing. And then Republicans in the same session. 2022, it shifted for whatever reason. But the point is, the General Assembly has been looking at practices in prosecutors' offices for the past 5 years, if nothing else. That is a valid legislative purpose. Now, the last slide that the petitioner showed you, number 14, says, well, this is all done at the behest of the president-elect. Of course, we don't have evidence of that. And statements of legislators is inadmissible in determining anything one way or the other. That's the Jackson versus Delk decision. But it also ignores that there are 9 committee members, and they've pointed out the acts of 1 or 2. It also ignores that if you look at, again, lines 55 to 58 of Senate Resolution 465, it focuses on practices, specifically practices of hiring special assistant district attorneys. The General Assembly has in the past looked at similar things. I think it was in 2016, roughly, maybe 2014. They placed a limit on district attorneys hiring special assistant district attorneys on contingency, because you had cases where they would go out, file RICO against folks, keep a percentage there, and they stop that. This may be if legislation comes from it. Again, we're in the investigatory phase, not the legislative phase at this point. And so there is a valid legislative purpose, if that is even matters, which it doesn't. So what petitioner really collapses in their argument today has crystallized it, is they're making a statutory argument, because they can't find anything in the state constitution that prohibits the Senate from doing this. And they cite 2 statutes. And effectively, as the court heard, their argument is there's only 2 places where the code, not the Constitution, the code says the General Assembly can issue subpoenas, and that is limited to those 2 areas, period. And because it says General Assembly and not Senate, it's over. It has to be the General Assembly. That's in effect their argument. There's a couple problems with that. One, no one disputes that the Senate committee is not the Committee on Ethics, so we're not even looking at Title 28.
Just cut to the chase.
Interestingly enough, Senate Resolution 465 cites to Code Section 451519.
Speed on it, do what happened.
I'll say the last word. You heard again. The Constitution does not grant. Let's make very careful here. The Constitution does not grant either the General Assembly or the House or the Senate acting alone the right to subpoena. That would have to be created by statute. And the statute says that it must be the action of the General Assembly. Could they not have to have the signature of the governor? Probably. I mean, this is new ground. The General Assembly has been in existence for over 200 years. Well, a good ways over 200 years. And no one body of the General Assembly has ever tried to do this. Now, the last word I'll say to you is this. Listen, it's very clear. What they're trying to say is, no, there's no authority to do this. This is just it's just something that we can bring in.
This is about the hearing that and I was just, who's scared? This is about the hearing where the committee was saying that Fani Willis, when they tried to subpoena them records and them receipts and stuff on what she was spending their money on, and what the Department of Justice sent her, all that stuff that pertained to the Donald Trump case and to the funds and stuff. Now, Fani Willis was saying, well, because she's an elected official, she don't have to provide documents. She don't have to, they can't subpoena her for certain things because, again, she's an elected official. So that's what they're going back and forth about. Now, I was saying the reason why I was breaking this down for people is because after her, okay, mind you, she just lost this case. The Fulton County just, the people that they got, they got, it didn't go the way that they thought it was going to go. They messed up a lot of money behind this case, and they also got accused of stealing people's stuff. You feel me? And so now, by them having to provide the receipts and show where the money went, it's going to start to show that, she was spending most of the funding chasing these YSL dudes. She didn't care about getting the backlogs caught up. They gave her a certain budget to get people out of jail. She was steady putting people in jail, leaving them in jail, trying to send thug them to jail, YSL, YFN, trying to send these people to jail who you don't even have a case on, but you coercing and manipulating people into taking these pleas to keep your jail packed so that you can continue to get funded. Now, we look at Fulton County Jail, it ain't one door in their jail work. You don't hardly eat in there. You don't get lunch. You get a sandwich. The people that's still locked up, and then y'all got the nerve to ask the commission, and the commission means that's why they said we're not giving y'all no more money. We're not giving y'all no more money. We done been more than generous. That's what Commissioner Rod Pitt said, and then they gave them $75 million. I think the $75 million was to redo the jail. They ain't did nothing to the jail. They turned around and thought that they was going to get the funding. I think it was a $2 billion fund to rebuild a new jail. But that's when the commission was like, no, we done gave you too much money. So that's why Ashley Merchant and them was like, well, look, we need to see where all this money going. If you giving her all these multi-million dollars and the jail, mind you, they locked Donald Trump up in the jail, which was completely dumb. You lock them up in there. He see the conditions. They see the injustice. They see what's going on. They see how y'all playing. So now they saying, look, we want to see these documents. Now, if she have to turn them over, which is going to be that's going to be a very interesting part of their hearings, because as an elected official, are you obligated to turn this stuff over? Now, one of the things I said earlier about it was, had Fani Willis, she spent the money on appropriate things, maybe not the jails, but other stuff. That's what they want to know. What did you spend it on? Because as far as what we can see, or as far as what you said, or what the money was for, hasn't been done. Now, that's why they saying if it's something else that you did with it, please let her know. But she can't say what she did with it, But that's the whole thing with the Fani Willis situation. Now, again, that's what I was saying. It's interesting. Oh, that's what I was saying. If Fani Willis was to go in here and have won that trial, the YSL trial, did a good job, proved our point, laid it out, boom, 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 got the win, got the YFP, cleaned up the communities, I don't think nobody would care nothing about where the money went, because we would see as a community what was going on. Fani has nothing to do with the jail besides putting people there. They commission to give the sheriff what they need. What are you talking about? Fani has nothing to do with the jail besides putting people there. That's a big part of the jail, putting people there. But the part that Fani Willis plays is she got people sitting in jail that they don't have a case against. Maybe. Or maybe the next case go just like this one. Maybe it go just like this. And then people see, because, I'm a firm believer. You ain't got to show me twice. If a person hit you once, they'll hit you again. Because and the only reason why I say that is because if this is Fulton County, they all do the same stuff. Facts. They all play the same game. And that's just what I done seen. You can go on the floor of the conditions of the jail. Okay, so look, that's why I had played that other video when they was at a committee meeting. Now, the conditions of the jail. Okay. The conditions of the jail fall on Patrick Labatt. But the problem came when the jail and the doors and all that stuff, the conditions became messed up because in 2021, when Fani Willis became district attorney, she passed that law that said, look, the 90-day law. So by her doing that, mind you, it was COVID time, so the courthouses were shut down when nobody going to court. So you got all these people in Fulton County. It's overcrowded. So if you put so many people in a facility and it's overcrowded, and most of them is street dudes and violence and stuff, it's gonna be wear and tear on the jail. It's gonna get towed down. But if you would have took the money that they gave you for backlog and said, look, if you've been locked up since this COVID and we shut down, we releasing you on probation or whatever, fine. Boom. Get you up out of here. A lot of places wasn't even locking people up. They was like, look, the courts is shut down. We ain't locking nobody up. Fulton County, oh, they locking you up. You'll get out when the courts open back up. But so they was giving them this money, you know. They even went to talking about, y'all heard when I was playing that. I was playing it earlier, matter of fact. Hold on. I want y'all to hear this, man. We know what's going on. We know what kind of games they playing. Let me show y'all something real quick. I ain't gonna play the whole thing, just a little bit, so y'all can hear this stuff, man. How they be doing them. Oh, dang it, hold on. There you go, right here.
Creativity is all around us on our daily journeys. In the spaces
Yeah,
we
check
have,
him out
during our
real
most
quick, y'all. How they
cherished
be
moments.
talking.
No one has not been enforcement.
Told you
Hold on, y'all
transaction 1
listen.
and 2 problems already.
Y'all got time to check this out.
those
Listen to how
needs, 1
Fani
and
Willis
2
come
have been
on here
resolved,
snapping.
but I can't do that.
Look.
Of positions receive. Is she going to receive it? Is there a
The other day after you asked me that question, that ORCA is actually not an acronym. It's what they have referred to for this COVID backlog. ORCA, and I can't make this up, is a big whale. I guess they thought because this is a big problem, they would call it that. I didn't make it up, but we need those funds.
Okay.
We need those funds.
Okay.
What you need them for?
So, Mr. County Manager, Madam CFO and COO, can you speak to this funding and what is the situation with this $2.46 million that the DA is saying she was supposed to receive? Is she going to receive it? Is there a, I mean, explain if you can, please.
Now listen to what they say. To why they didn't give her the
Yes,
money.
ma'am.
I
And
asked that
listen
the
to
chart that was sent by your representatives at those rates and those positions, if we are actually going to get that, or if we're going to keep going through this song and dance.
I don't know of a chart, so you're gonna have to
want that
tell
money,
us
Shawty?
about that because I don't know about a chart. I haven't received. Has anyone on this board received a chart of positions or something?
I'm gonna explain
sure
some
they're
stuff to y'all tonight. The lady who she's talking to,
Is there a chart, Mr. County Manager?
Okay, so I gotta explain to y'all, man. This is deep though. So look. The lady she's talking to is Natalie Hall, okay? Natalie Hall had got caught up in a scandal and she paid her accuser. Natalie Hall was allegedly like stalking this man and doing all this stuff to him. He sued her for $1 million. They cashed it out, kept it going. Fani Willis, started trying to kind of use that saying, oh, well, when she got in her situation, y'all gave her $1 million and her accuser went away because Misha Maynor, who was a state representative, she started trying to file charges on Corbin Munson. I want y'all to pay attention to it because I'm showing y'all how they trying to move the money around and circulate it, and then they hide it in political campaigns and politicians. Man, I ain't trying to say too much, but I know a lot about what's going on. I was right there. I was like, "Ooh, I see what was going on." I was like, "Man, I don't want to get caught up in that." But so that's what's going on. They talking to Natalie Hall. Rob Pitts is the head commissioner, but they the ones who give them the money. Now, I want y'all to hear what they say about Fani Willis because Fani Willis is buddy with Shay Alexander. Shay Alexander is the now solicitor of Fulton County. For years, it used to be it was another person. What was the guy name? The clerk of court for Fulton County for years was the same Kathleen Robinson. It was Kathleen Robinson forever. When Shawty got in there, they kicked all them folks out and brought all they folks in. Shay Alexander was just a contractor, a Fulton County contractor. They play with all the money. The lady gonna say that, like, ain't she just a contractor? But being if you over the contracting department, you can give contracts to your buddies. How you get a contract. It ain't what you know, it's who you know. So she in there telling them folks, look, Shay them already approved our money. Where that money that y'all supposed to give her? But the board is like, look, we didn't agree to give you this money because first of all, the prices, the quotes that y'all wrote up and y'all thing ain't accurate. Like for example, and I'm gonna play it for you. They're like, look, it say how much would this amount to be for this person? It say like $75,000. They're like, how can something be exactly $75,000? The numbers are whole amounts. They talk about it, but that's why she went to saying, look, and pat the back. Whatever we decide to do with our money, we don't have to answer to nobody. That's why I was playing the hearing that I was just playing because they saying, oh, the hell you don't.
Measure that she's talking about that you can share with us?
I'm not sure exactly what chart she's referring to, but as we presented today, the budget for the court backlog reduction is now at 75 million versus 61. So it is fully allocated in terms of the resources that we have from the American Rescue Act. So now, I guess from a does she get it, I'll turn to Sharon, but now the process is that it's fully funded, the positions are allocated, and she has the ability to hire. But let me defer to Sharon.
Is this the sheet that you're speaking of that's coming?
Yes, Vice Chair Hall, that is the chart. These are the positions. Those were the rates of pay we were told that was agreed upon. As you see, it is in writing, and I just want to make sure that it is honored because I did 2 transactions and already there were problems.
So who told you that this was approved? Because I don't see, I'm looking for the county manager, the chief financial officer, and the COO at least to be on here, and Hakeem, our director of finance, but I don't see any of them on here. On this email, it's coming directly from Shay Alexander, who isn't Shay still just a contractor?
Yes.
So she told you that this was approved?
Yes, we met with Mr. Adams and Miss Alexander. We did that for months. We wrote out the positions. They met not only with my office, they met with every justice partner. We worked out the things, and then we were sent that this is the list of how you are to do things. And so then we began to do things in that order. And as I told you, transaction 1 and 2, problems already. And so those immediate 1 and 2 have been resolved,
didn't
but
have
I can't do
permission to
that
go
for
and spend the
transactions. I've heard
money.
you all today talk about hiring for different projects. And what I have to tell you is I've been hiring for the last 6 months, and every time it is difficult. And so I want to assure that what we said was going to be done is going to be done the way it was outlined for us.
Mr. County Manager, did you know about this document that was given to the DA and said it was approved?
Yes, ma'am. We met with the DA and discussed it with her recently. I think it was Friday.
Okay, and so it was approved then?
Well, fundamentally what the disconnect, I guess, if you will, was Shay, and don't let me speak for you, where did Alton go? But Shay and Alton were working with all the justice partners to outline the plan for court backlog reduction. When this document was put together, to the best of my knowledge, and you can look at this and somewhat surmise this, these salaries are rounded numbers: 75,000, 53,000, 80,000. They are not precise numbers. So as the DA went forward to hire based on this, which was essentially a consultant working document from Shay Alexander, as it so happened, the first 2 that went forward did not have a good coordination with HR, and an offer was made to 2 people that's slightly above the authorized salary grade, the higher limit of the salary grade. So we did have to get together and either do one of 2 things: change the offer letter back to the lower number, which I don't remember, Ken, exactly what the number was, but let's say $15 less.
The man said these is not precise numbers. Y'all just making up stuff.
Position title to a higher title. And that was the decision that we collectively made.
And so are you currently working on moving forward with completing this list of hires?
Yes. So, and let me ask Sharon to speak to the plan that we gave to the DA that I think will facilitate not only better working, but elimination of any miscues.
Thank you, Mr. Manager. Vice Chair Hall, the one thing that we, after the meeting with the district attorney, we have the HR staff reviewing the list to validate that the grades and the salary ranges all are in line with what our grades and salary ranges are, and that we don't have any more issues relative to that process. We've also shared with the DA from a procedures perspective, the time frame and the timeline for offers to be made, to make sure that the offer letter itself is reviewed by HR to ensure that it has all the correct language, since these are going to be time limited positions, and that the title and the grade and the salary on the letter all agree to what's in the list. And so there were a few, I think, issues that needed to be corrected on the list, which HR and Shay Alexander and the finance department have been working on the last couple of days. It's not just the list for the district attorney. They're reviewing the entire list of all 300 plus positions for the backlog project in general, just to make sure that we don't have any other issues pop up like this. The DA.
Now, y'all heard this lady. Fani Willis done went in there and told these people she finna hire 300 people, a district attorney, work at the district attorney's office. 300 people. She said these people gonna want 80,000, 20,000, all this like that in the third, right? She goes out right now. Y'all just heard her. She go to try to spend the money, and it ain't even been approved because they saying, look, we got to look over this. You need to tighten some of this stuff up. You talk to HR, you talk to these people, but you out here trying to spend the money that ain't been approved. Slow down, cowboy.
they just happened to be out in front on this. So we are trying to work through these issues and get her where she needs to be relative to continuing to move forward. The positions are staggered by month. And in addition to these positions, we also are working with the DA so that she can utilize her salary savings that she's accrued this year to be able to hire some.
Same thing too, till I had the pleasure of seeing County Manager Anderson in the parking lot and told him that when I spoke to the commissioners, they all said that wasn't right, Commissioner, from the mighty District 6. And so after I can get to you, then things change. And so I won't speak because I want the sheriff to be able to utilize some of my time and speak. And I want to make sure you know that this is the struggle that we are going through. And quite frankly, Commissioner Hall, I've told this, I don't say anything behind someone's back. I don't say to their face. And what I have told your county manager, your employee, is I don't have the bandwidth anymore for these games. I need to get to the business of solving crime. And I believe the sheriff wants to address you.
Sheriff Labatt.
Everything in proper order. Let me be clear.
I don't like this dude.
First of all, thank you, Madam DA. And I said this repeatedly, we got the baddest DA in the country.
Mm-hmm. Yes, indeed.
Oh.
So the line, I didn't just come up here to be cute. And this
need the
vest is for a
attorney to
reason,
with the
'cause I had a
backlog.
county
Backlog, that was
commissioner
two,
say
that was
that
2-3 years ago.
sometimes sheriffs talk big. So I don't play one on TV. I am the sheriff of Fulton County. I'll be on the street tonight fighting crime.
Yeah.
We started putting people on the street long before tonight, working with APD, working with Georgia State Patrol, creating a Scorpion team that's going to fight crime. We're going to give, I told Madam
Mind
DA,
y'all, the
we're going to fill your
Scorpion team,
desk
the
up.
same one did that Mr. Tyree.
We're going to
Ripple.
fight crime, and we're going after
I ain't
these
gonna say
bad
nothing.
guys. Some of y'all thought I was playing. I don't have a fancy PowerPoint. I will ask for permission to be on the next board meeting. Can y'all put that in whatever the 28-day cycle is? Because when I first started, I said I learned that I had to be 40 days ahead of the conversation to even come speak to y'all. See, I'm not used to that.
That man crazy.
Let me back up and say thank y'all. Thank you for coming to visit. Thank you for having the conversations. Thank you for the $6.8 million. Let me be clear that I had to get 4 votes on, right? I can do the math. Only to find out later, it wasn't a pay raise. It was a salary adjustment. Let me be clear. We are underpaid and overworked. I had 15 people in the last 30 days leave the Fulton County Jail as detention officers to go work somewhere else. I text you every time I see Sandy Springs offering $7,000 to come work for us and a $3,000 relocation fee. Cobb County offering $5,000 and a $2,000 relocation fee. It's a tough time to be in law enforcement.
Wow.
But each and every one of you call me when you're going up Bankhead Highway and it's nothing but ATVs blocking the street. But I can't get a Bearcat after I go through the process. Mr. Davis, thank you, I appreciate that. Of playing you all's games in finance, because that's all they are. Everybody wants to move the goalpost when we get to the end. It ain't your money. It's been approved here, and I'm going to spend it accordingly.
And I'm
the
going to
next
spend
time,
it accordingly.
Ms. Whitmore,
Y'all here?
and I've sent you emails, and I appreciate you responding eventually. And let me be clear. When I sign my name as the sheriff, which one of y'all, when you sign something on your staff, write a check, Ms. Whitmore and her team rejects? Because we just haven't done it that way. When I work a deal to get a Bearcat so that I don't have an breakdown on Georgia 400 on the way to a SWAT call where a guy has been charged with killing 28 people. Ends up killing himself. My MRAP sitting on the side of the road.
Happened?
But I put a plan together following the rules.
I must have missed
This
that.
county manager, I appreciate it. We have a relationship. That's what this county's not used to. We talk 2-3 times a week.
Right.
We talk, and I appreciate that. But what we have is a bad culture.
Terrible.
And we need to figure out how to fix it. When I signed something, I was elected to do it. I'm going to manage my budget, I promise you. But don't tell me that these salary savings I can't use to do other things proactively. When I've heard for 2 years, I ran for 2 years, and what you heard was the sheriff just didn't really come to the board. He didn't talk. I would encourage you to understand this, and this is not you all's fault. Let me be clear, because as I've churned and overturned Plymouth Rock, what I found is the rock landed on you. You didn't land on Plymouth Rock. And so what you were getting was bad information. And so when I come to you and tell you that I got a canine unit,
land on Plymouth Rock,
that in the middle of a search, the unit goes bad, we got to borrow one from Clayton County because it doesn't have air conditioning. My dogs deserve better. When I tell you, and again, thank you, I appreciate the conversations around the jail. And I appreciate the passion in which the county commission has said to the city, we got to do better. And we will. And we absolutely will. But let me tell you about the equipment.
He said,
I ordered rifles the SWAT team hadn't had in years. And somewhere along the process, be it my folks, be it finance, we ordered $90,000 worth of rifles, the best equipment you can get.
Worth of rifles.
Oh, I'm sorry. Somebody in finance said we had to send the sights out for the rifle. Let me put that in. You look through a sight to make sure you can hit the target down range. But because of our processes, 30 days later, the sites are approved. And guess what? They're approved by the same vendor. We have a flawed culture. It is time we fix it. And if you don't believe we're out here fighting crime, come meet me in Metropolitan tonight. Right? You don't believe we're out here fighting crime, meet me out at Fulton Industrial. We put the necessary resources in place, but it's like pulling teeth. It is absolutely absurd. I do want to give a shout out to the county attorney and her team. The 11th Circuit ruled in our favor today. Hopefully you can give the board some update on that, because it's good news about how we treat people. See, I didn't just get in here to walk around. We are going to handle our business. I am going to bring you the facts. And Commissioner Hausman, I appreciate you asking for the facts. But we are going to bring you what you need in the next board meeting, right? That will show you that we are $20 to $30 million understaffed if you want to have a true sheriff's office in your county.
Did he jab for $20 million?
We are partnering with all 15 cities to include colleges to get the best training we can get to give our citizens what they need and deserve. See, what I come to learn is that you being plural in many instances didn't understand the breadth and aspect of what the sheriff's office actually does.
They don't went up
on a daily basis.
Man, Texas has it.
I appreciate the additional conversations so that we can, but now we're 6 months in. The education is gone and we need your help. So I wasn't privy, and I appreciate Alton and Shay in the conversations around this rescue money. But when I said I needed 50 deputies and it comes back on that chart that I'm getting 15, somebody didn't hear me. Or the allocation of funds simply was not done appropriately. I don't get it. I come from good government. And I'll tell you publicly what I've said. The city's behind five years behind the rest of the world, and the county's 10 years behind that. You don't get it because you breathe rarefied air, right? Everything you get in here from this board over, right? Outside personal meetings is, yes, Commissioner. Yes, Commissioner. this is what we'll do to fix it, Commissioner. And so we thought it, my sister and I thought it.
He ain't said nothing about the jail and the inmates.
To give you what we honestly said we were going to give you from the beginning of taking office is the hard facts.
Nothing.
The truth. I appreciate the time. I do indeed. I appreciate you taking my call, Commissioner Hall, every time. I appreciate Chairman, every meeting we have. No one has not been responsive to the call. It's time to vote. It's time to put the rubber on the road. It is time to invest in public safety, and not just on the telephone. It is time for us to really show the citizens of Fulton County what a sheriff's officer can be, what a DA's office can be, if properly resourced. It's simple as that. It's simple as that. And so while the notion was, not notion, the facts were, we didn't get a chance to transition. But you didn't either believe in us when we said the fat meat was greasy, or you wanted to give a test of time. We're 6 months in. And it is time for us to look beyond where we are. I was so happy the other day, I printed it off, I sent it to your office, and I'll make sure everybody has a copy when the president said we can use this rescue money to fight crime. Let me give you an example of what this looks like. Look at the largest sheriff's office in the Southeast. We use these things that we call tag readers. We mount them to cars, $17,000 a piece, right? For the whole setup. We have the sum total of one vehicle that can read tags. And it's broken down. So when I work with Joe, when I work with director to put together the equipment I needed, we got women and men out here protecting the best we can, and we're not resourcing them. You heard the DA early on, and you mentioned it, Madam Commissioner, about vests, right? I got vests that are expiring. The expiration date long gone. And maybe some of y'all thought this was for show, but I can't go to a funeral because of a vest. I refuse to. And maybe it's a culture that you just were not informed. I don't know what the answer is. But what you will get is transparency. What you will get is honesty. But we need somewhere along the lines, Mr. County Manager, the understanding that when the DA and the sheriff, we're elected just like you, right? See, some of y'all are confused, and maybe this is for the audience, because every time you say sheriff's department, the hair on the back of my neck stands up. I don't run a department. I run the sheriff's office. And it's insulting to say otherwise. So I say that to say, here's the good news in all of this. We're on the way up. We're on the way up. We don't have nowhere else to go but up. Let me be clear. Let me be clear with my choices, right? But the DA laid it out for you. My heart breaks every time you see someone get killed in Fulton County. But let me take it a step further. And I'm gonna wrap this up. I got a secondary phone. That phone is tied into 911. That 911 system goes off every night. Every night. In Atlanta alone, and DA can give you the rest of the 14 cities. In Atlanta alone, somebody's either shot or stabbed, carjacked or robbed. Every night. Or trafficked. Every night. Every night. And we have an obligation to do better. We took a duty, we took an oath to do better. And we want to be good partners in doing it. But I'm afraid sometimes you all don't get the whole story. And so we thought it necessary to come and have that conversation. And so I'm going to get out the way of my
Thank
sister.
you, Mr.
And I
Sheriff.
certainly appreciate
So
it.
Commissioner Hall, because I know
Yes.
you said you like receipts. See, I've been watching you all day.
Look, she back.
Yes,
to the point.
ma'am.
She back to
When
the money.
DA has an assistant chief, Clark, stand up, please, that spends 1,000+ hours and 28 meetings to try to get an evidence facility straight, to do the architect, to work with who are supposed to be our partners, and does it along with
I agree.
1,000 hours with the sheriff, and also the attendance of 28 meetings. And we are guaranteed to be on this agenda for the 14th, because if we don't get this facility, cases are going to get overturned. And then no one even gives us the respect to call and say it's not on the agenda. We're not going to deal with it. Although when I met with Commissioner Morris and Commissioner Hall and Commissioner Hausman, they all said, but you told us about this in January.
Hey,
Exactly.
how you doing? How everybody
And
doing?
since January, we've been doing the work. See, if my people treat any one of you like this, this is what they can each tell you. They're going to be fired that day. I'll deal with the consequences later. So I'm asking you to get your staff together so me and my brother can stop being treated like this.
I'm so sorry because I didn't see anything about an evidence facility on this agenda.
And she
any,
want to
I told you I didn't see anything. I didn't know anything about it. And so I just want to make sure that I get all my answers. I did hear Madam CFO say that the salary savings
you need about $100
that you
million.
have would be used, that you will be able to use
She
them.
really
And
wanted a
I just
billion.
want to make sure this amount on here is correct. Is $641,000 in salary savings, Madam CFO?
We calculated 617 for the salary
I'll take the
savings.
617 because I was told I can't use anything.
All right, so 617 it is, going once, going twice.
I take the 617.
All right,
I couldn't get nothing.
so you're gonna move forward with these positions to help the district
She just
attorney
went in
try
and
these
got her
cases, because I heard you loud and
$617,000
clear
real
when you
quick.
said that over 1,000 people
in the wrong
could
business.
bond out and get back in the streets, and these are serious crimes. These are not just, I jaywalked, I spit on the ground, I'm loitering. These are serious crimes, and I don't want to see not one of those people get released out just because we didn't do what we needed to do financially for your office. That makes no sense whatsoever.
Commissioner Hall, I would ask with my brother that I could be on the next agenda so that the other pot that I want to deal with, because we have been strictly told that money is for COVID, and it's all right because I have enough to do with COVID, that we can ask for the other 2.5 that I referenced in the PowerPoint to deal with the rest of the cases. And so I would ask to be on your agenda.
So let me ask that Alton never came back. Well, let me ask this question, Mr. County Manager.
She just asked for another
In
2.5
the
million. They just gave her
COVID-19
$600,000. She just asked for
that was
2.5.
just passed, it says that there's a court case backlog line item, but it only is speaking to cases. Is there, can we add a line that specifically addresses these areas for the sheriff and and Madam DA? And can someone
What's going on in
confirm
Fulton
if
County,
we can
y'all?
use,
They ain't
whether or
trying to
not
tell
we
y'all
can use
about
ARPA
that.
funds for what they're looking for? Because as I stated in the last meeting in June,
Go ahead and
reading
get
the
$600,000 out of
ARPA
town with real
website
quick.
information, it said
Woo!
specifically that President Joe Biden
Can I have
set
one too?
aside these funds that can be used toward law enforcement and can be used toward preventing violence and funding peace. So I would like to see that you go back and add a line for these things and let us know what can we fund through ARPA so that we can at least have something to move forward.
They gave me $617,000. I'd have left right then. Thank you. Bye. I don't know what he want to get, but I appreciate y'all. I catch y'all next week when we come do this again. All right. I'm gonna need that 2.5 million. Y'all make sure y'all have that ready to sign off. We're gonna be ready to go. All right, bye-bye. But they're my boy right there, though.
To know why we are here
Here's my
at
boy
this
right
hour.
here.
Why are they
Watch how he go off.
Why would you tell them they can't get their salary savings? Why would you not expedite their hires? She said coming in, she's going to get rid of 70 people and hire 130 people. We've been knowing that for 9 months.
Arrington. And it's crazy because that's what I was trying to pull up
So
with
how
this
do we get
video.
to
It's
this
right here in
point
my face.
where she's out trying to hire people and we're having hiccups? I want to say it's unintentional.
Uh-oh.
But then when I look on the agenda and I see Commissioner Hausman talking about, oh, we passing the lowest millage rate ever. Fuck the lowest millage rate. We got to get these people locked up. They got to be arrested. I don't give a darn about no damn low millage rate. Where's the money that the DA's office needs? Where's the money that the sheriff's office needs? Where is the cooperation that they need? It's not even really the money. Where's the cooperation?
Yeah.
They gotta spend 1,000 hours to negotiate a damn lease, and then gotta come down here and wait 10 hours to fucking speak, and y'all won't give them the money that they need. You won't cooperate with them to give them to be able to hire the
32
people
now.
that they need.
His daddy was a top dog. His daddy was like a Supreme Court judge, I
Mr.
believe.
County Manager, please make sure that this never happens again. But see, when somebody sneaks the lowest millage rate ever on the agenda,
Honeybook completely changed how I do business.
Hey, but it don't be playing though. But it get deep though. It get deep though. It get deep because Marvin Arrington was representing Corwin Munson. Corwin, man, it get deep. It get deep. He represented Corwin Munson, and Corwin Munson was accused of some messed up charges. But them dudes that Marvin Arrington, who you just seen, they pay the judges. They pay everybody. These folk work for them. You feel me? These people work for them, the judges, the district attorney people and all that. They giving them that money. You seen Fani Willis down there going off, let me get my money. Jay, give me my money. They ain't talking about the inmates. They ain't talking about nobody getting out of jail. And then on top of that, y'all pay attention. They said we want you to, Natalie Hall said clear as day. We want you to have the money and the resources necessary because we don't want to see these guys back out on the street. Didn't she say that? We gonna give you everything you ask for. We gonna give it to you. We gonna work this out. Yeah, we gonna give you. Look, we gonna give you $617,000 a day. You feel me? Because that ain't nothing to them. We gonna give it to you today, but we don't want to see these boys on the street. You done let them all back on the street. You done let them back on the street. The majority of them. You know what I'm saying? So now they looking at you like, what was the point of us doing all this? You think we finna do it again on this next trial? No, no. Work it out. That's why Paige got up there and said, look, y'all need to go and make a plea because we ain't finna do this. What y'all want to do? So y'all gonna plea this out because all this back and forth and what y'all think y'all finna have going on, we not doing it. If y'all got a case on them? If not, let them go. If y'all don't got a case or defense, take the plea. Let's get it over with. Everybody go home, get this over with. Makes perfect sense to me. But see, I'm gonna tell you the truth. I don't believe they got the money to really go back to back the trial like that. They might want to try their look. They just messed up a lot of money and resources and community relationships with this. Now, it don't matter. The next people that's finna go to trial, this scared me. It's gonna be hard Now you might can find some people, but y'all keep up with me on the move. They supposed to work for the people. The boys, they just there to allocate funds. That's it. They just move that money around. But look, it's gonna be hard for them to pick a jury that's gonna be able to say, "Oh, I don't know nothing about the YSL case trial, rather." All right, and even if you do find 12 people that just so happen to not know nothing about the YSL trial, that's gonna be hard to do because everybody talking about it. So you mean to tell me somebody gonna go in there who know about the YSL trial, get on the jury, and then not have a biased mind or have an unbiased mind? Yeah, Whitaker was cool. Whitaker was cool. Whitaker tried to help them out as much as she could, but them folk, man, they were their own demise. I'm talking about the state. The state messed it up for themselves, man. Lord got upset, got cocky. Hilton really didn't know what to do, and Shawty tried to save the day, but it was a little bit too late, buddy. You know, but you live and you learn. But y'all gotta, they messed that case up. They messed that up. I'm sorry. I ain't know what to say that. Y'all didn't have nothing. And but see, fight to the end. But y'all will get y'all had. Y'all had. And at some point, I was like, okay. In the beginning, I don't know. I don't know. Sometimes I was like, yeah, they going. Then the other times I was like, man, they not proving nothing, you know. But even going back to the money, you got people that going in there that were trying to prosecute these boys. And mind you, I said this earlier. The Department of Justice did not investigate YSL and Young Thug. The Department of Justice could have investigated them and sent them to prison. The feds wouldn't have went in there playing. The feds would have went in there with the wiretaps, with the informants, with the woo. They would have went to prison messing with the feds. But the Department of Justice said, we're going to investigate y'all. Y'all running around here chasing YSL. We investigating y'all. Why y'all so tired of and Young Thug, Jeffrey Williams, and all them boys? We all in y'all system. You hear? We all in y'all system. Got the Department of Justice all in Fulton County Jail investigating people that's losing their life, people who getting their rights violated, people who ain't been to court, mental health patients. They in here doing a whole investigation on your jail facility and your courthouse. And your courthouse while you running around here playing with Young Thug. Man, please. Please. And I'm gonna tell you something else, because that hurt my heart, man. And I get what people saying, but old boy, mama hurt, man. What's her name? What's his name? Nut mama. You know, she hurt. And we know what's going on, man. We know, and I don't know. I just wanted to play it for y'all in case y'all haven't had a chance to see what Nut Mama said. Have y'all had a chance to see it? Nut Mama spoke out. I'm gonna just play it for y'all.
And do this for my baby. And come see him. Let him know it's okay. We're gonna be all right as a family. Because they might not been found guilty in the eyes of the law. And those fake ass jurors they had up there.
Ooh,
but guess what?
Fake ass jurors.
We got this. Because we know the truth. We know what happened. And I just had to come see my baby, let him know that we got this. It's so sad. Just as I was in the end. And it's always gonna be lonely enough forever. I'm just mad as hell. And I ain't gonna say I'm mad at the state because them people did what they can do. And just those bouncers got there and lied and played, and I was paid off, even to the jurors. The deputies, they were all full of bullshit down there. They only saw what they want to see. And people who, the bloggers and all that, they didn't see the inside of what was really going on in that courtroom. I know in my heart of heart and stuff, I was paying attention to. It was a lot of injustice going on just with people, period, in that courtroom. From the deputies, I know for a fact. And just stuff that was going on in general. But at the end of the day, we got this. It's always, like I said, gonna be long live, not forever. I'm gonna be okay. We as a family gonna be okay.
Hey,
and we're gonna get through this.
Y'all seen that paperwork? Well,
Right now, I'm just mad.
hold on.
I'm upset.
It's so sad.
My bad, y'all. I'm finna show it to y'all. Y'all seen that paperwork where Kayla Bumpers is now representing Shannon Stillwell? Have y'all seen it? I had forgot all about it. But hold on, I'm just show it to y'all real quick. I don't even feel like loading it up and everything. But look, I just want y'all to see this real quick. For people that ain't seen it. Look. Hold on. Yeah, y'all can't see that. It's a entry of appearance. Okay, so Shannon Jackson, the defendant, entry of appearance, you know what I'm saying? That means she's starting to represent him. Okay, yeah, for the guy that ain't the courtroom was it. So yeah, well, yeah. But she done entered the thing. Yeah, she done entered the entry of appearance to be his attorney. Like, this is crazy. But yeah, this is crazy. I don't even think a wife could represent their husband.
But I still got my faith.
Yeah, they married.
Grace and mercy and the higher power that we do serve.
They married.
And I just had to come
A
let
wife
my baby
can't
know
represent
that
their husband. This is
Mama was
crazy
there.
stuff.
Your daddy was there.
Oh, dang.
We was there. Ned was there. Your stepmom was there. We fought a good fight. And we're gonna continue to fight. And we're gonna be okay. We're gonna be okay. But Mama just had to come see you. And just talk to you and let you know. I'm like, I have never got on here just to broadcast my business. And spoke my piece. Well spoke. But right now, I think it's time for me to do this. I sat there and I didn't want to go down to hear a verdict. And I kind of wasn't in there. But I already knew it was going to be some bullshit with this. I just kind of felt it in my spirit this morning. So I kind of procrastinated. And we got there, of course. It was the unthinkable was heard, not guilty. But though they know they're guilty. They knew in 2010, January 15th, that they were all guilty. And the parents, they could sit down there and clap. I'm without words, y'all. I'm without words.
It's just
I truly am without words. But I just think I have for the love and support that people have been there with my baby through this process. And to all the people who just, it was so many. This case was tried basically on social media bullshit.
Yeah.
All those bloggers.
That's social media bullshit.
That think they know the system and what happened. We as a family, we the people know what happened. We really know what happened. But
can you hear me?
Like I said, at the end of the day,
yes.
We as a family, we're gonna be okay. We're gonna.
You'll be all right, y'all. I mean, hell, I think Edmonton might be next. Yeah. Now, see, that's crazy. That's crazy because he did hit them. He did hit them police. He hit the police officer 6 times, then something like that. But I don't know. I don't know. He might. I don't know. I don't know. This stuff is crazy, and you know how the law is supposed to go, but they done proved to me too many times that the way the law is supposed to go, it don't go with them. It just don't. You got people marrying people. You got people telling on people. You had people snitching on each other, and nobody got convicted. I ain't never seen this. I've never seen this. None of this makes no sense to me. And then in the end, I ain't gonna lie, y'all, I would have been scared. Hey, man, listen, I'm laughing, but I'm laughing because I know it's true. They scared Thug. Thug was like, man, I'm finna take that plea and get up out of here. 15 years. Bet. I promise you they scared him. Yak mama told y'all when she told him. He said he ain't taking it. Yak wasn't scared. Thug no folk was like, man, I ain't no bad guy. I ain't got nothing to do with these niggas. Man, Thug got up out of there. Shannon, okay, the little firearm, cool. But see, this is my thing. This my thing. Shannon still will. Now y'all keep up with me. He got charges. He got the he got them charges that he caught while he was locked up. They similar charges. Contraband and the other one now. So it depends on how they if they gonna try to force the issue about that. They be like, look, you just beat us on this, but we gonna get you on this contraband, which that's on the government facility. You feel me? And then they hit you with the G charges. You know what I'm saying? Like they can try to throw the book at you, and that's got cameras in there. But I'm just saying. Now you done got this lady. Oh, okay. So I'm assuming that he got Kayla Bumpers to do the entry of appearance because, like they said, she good for getting you a bond. So she gonna go in there and try to get him a bond because ain't no way, and she gonna do that for him for free. She ain't gonna charge him nothing. Oh, that's my husband. I'm gonna goddamn figure this out. I'm gonna go in there and get you a bond, and then we'll just get you an attorney to fight the case. You feel me? Cause they gonna try to hook and book it. I don't know. I done seen dude get bonds on that though, and it don't be that much. I think the bond be like 10,000. I think it be like 10,000, something like that on this stuff. You know what I'm saying? Something like that. You'll get a bond on it. I don't know, man. I don't know. You supposed to, cause he done been in there that long. He'll get a bond on that. They'll get a bond on that. It might take back. If they do a emergency bond, it can take like 7 days. If they do a emergency bond hearing, really, anywhere from 7 to 20. You know what I'm saying? A week to 3. Yeah, he said it ain't unrealistic, but at the same time, y'all got to keep in mind that's why she filed that entry of appearance today. So if she filed entry of appearance, she got to file a motion for a bond hearing. What that shit said? Waiver of arraignment and request for time to file additional motions. Request for time. What she need time for? But the other motion she gonna file, the next motion she filed gonna be a bond motion. She gonna try to get them a bond. That's gonna be the next motion. So I don't know why she would ask for more time. She just file. You should have filed that then. You should have filed the bond motion when you filed it. Well, I guess you got to file the entry of appearance. I don't know. Seems like she should have filed that and filed the motion for a bond hearing. Which she probably did. She probably did do that. I mean, that make more sense. unless he already got a bond. But then why would he? See, something ain't right with this stuff, but it's all good though. It's all good. But all right, y'all. I'll catch y'all in a minute, man. I just wanted to come together, man, and talk to y'all about what we're going on with Fani Willis. We got a plethora of things that we're gonna be talking about. Make sure y'all got y'all notifications turned on, man. One Life Family.